My name is Gareth Naylor and I'm a partner and head of personal injury. Whether or not you have a claim will depend upon whether or not the injury was sustained as a result of the negligence or breach of statutory duty of another. There is no set time period in which a personal injury case can take to conclude. Ordinarily, a common whiplash type claim from a road traffic accident could take 3 to 6 months. An accident at work or a public liability claim may take longer, that might be 12 to 18 months, but it does very much depend upon the complexity of the case and the severity of the injury sustained. You have 3 years to pursue a claim from the date of the accident or from the date of the knowledge of the disease or condition sustained. You can make a claim on behalf of the estate of a deceased and also on behalf of the dependents of the deceased. Once again, that will be subject to proving that the death was caused by the negligence of another, and the heads of claim that can be pursued are limited to those heads of claims under the Fatal Accidents Act and the Law Reform Miscellaneous Provisions Act. Five of us in the personal injury team, 5 lawyers and 1 paralegal, each one of us boasting over 20 years experience. We do home visits. We're happy to see you at your house, at our office, or we can deal with it in correspondence. It really does depend upon, again, the complexity of the matter. But we're always willing to visit the client at their home if they feel more comfortable. You can still make a claim if you haven't seen your GP. It is preferable to have an entry within your GP records, but absent that, we will get you seen by an independent medical or legal expert. He will examine you and provide a report detailing any injuries sustained. You can still claim, even if nobody witnessed your accident. You would normally expect an employer to record an accident in the accident book, and that would be the contemporaneous entry that we would be looking to rely upon. So it's vitally important that when signing an accident report form, you ensure that the contents are accurate, because you could be bound by them. No, we would get a copy of your medical records, but your own doctor cannot provide a report in support of the claim. The medical report must be from an independent medical legal expert who will have the training to give evidence in court at trial if need be. You can private fund a personal injury case, but it is very rare because you're unlikely to recover those costs in full on the basis that the majority of personal injury work now is captured by the fixed cost regime. A no-win, no-fee agreement, also known as a conditional fee agreement, works in the way that, win or lose, you don't pay us anything out of your own pocket, providing you're not found to be fundamentally dishonest and providing you don't fail to beat any offer made by your opposition. If we're successful with your claim, then we will take a maximum of 25% of your damages. Legal expenses insurance does cover this type of work. We would need to write to your legal expenses insurer asking them if they will provide indemnity. They are obliged to provide indemnity upon the issue of proceedings. Prior to the issue of proceedings, they can insist that you use their panel solicitors. You can also secure a legal expenses insurance policy after the event, and we can advise you upon that when the need arises. Legal aid public funding is not generally available for personal injury claims. There are limited circumstances where you could get an exceptional funding certificate, but that would generally only be for the more complex and unusual matters such as sexual assaults within a care home, death in custody, or maybe an unexplained death in a hospital. If you require any further information regarding a personal injury claim, then please call Ison Harrison Solicitors on 0113 284 5000.